Well, hello everyone. My name is Barbara Ann Foley. I'm the Council on Aging Director for Harwich, and I am back in the studio with our wonderful friend, Attorney Arthur Crooks. We have probably the largest multiple CDs or DVDs that we've ever had with Arthur's first show. So we're hoping that you'll tune in, and do know that every show that we do here, you can get a DVD of and a lending library of our DVDs. And we are going to be covering a 4-part series to begin with Arthur. So if you miss something today and you tune in another week and it seems like it's a different part, it is. So we will have these available for you. We're going to get started because we have a lot of topics to cover. Arthur, why don't you take it away?
Thank you, Barbara. And following up to what you said, the show that we had in December was an overall survey of basic estate planning concepts in Massachusetts. And what we're going to do over the next couple of sessions is go into these in detail, each particular aspect. And again, to follow up on what Barbara Ann said, these will be on my website, www.crookslaw.com. The December show is supposed to be up there now, and as the shows here are done, I'll be putting them on the website. So you'll have an availability here at the Senior Center through Barbara, and hopefully I'll be able to get them on my website. Now, what I want to do is similar to what I did in December, just give a little introduction to myself. Arthur Crooks on Old Jail Lane in West Dennis, and we can reserve comments on that until some other time. I've been there about 20 years. I'm a local attorney. I cover the Cape. I don't have any off-Cape offices. I do get out to Nantucket occasionally. And I'm vice chairman of the Council on Aging in Dennis, and I've handled these various issues, or been dealing in these various issues of what we call elder law for quite a long time now. Now, what is elder law? Basically, it's any field of law and how it may impact those who are considered elders. And my definition of an elder is anyone over 55 or anyone who wants to be over 55. So it's quite all-inclusive. As I was mentioning to someone over the weekend, when I first joined the Council on Aging in Dennis, they had a problem because I was too young. Time took care of that. That's no longer a problem. So what I want to get into in this morning's session is advanced care directives. And the first set of advanced care directives I want to address are probably the most important. And these are health care directives. Primarily the health care proxy, the living will or advanced directives, and what is called a HIPAA consent. When people call my office or come to me and they indicate they'd like a will or a trust, I always say we're going to start at the beginning. And the analogy I use is building a house. You build the foundation first. And the foundation are these advanced care directives that are for you while you're alive. And the last one, which completes the 4 corners of the foundation, is the power of attorney, which we'll be talking about in a coming session. Now, these are extremely important because if there comes a point in your life where you cannot speak for yourself or you're incapacitated, we want you, by completing these documents at a time when you're capable of doing it, to determine who you want to speak for you. We want you to take control of your own life without leaving it up to the courts, which segues into the next reason that I think these documents are so important, and that is something I mentioned in December. Massachusetts instituted a whole new guardianship set of rules and regulations and law last July. It's one of the most radical things that's ever been done in this field of law. But what it's done, it's made it vastly complicated. And what I want you to do is to be able to have your documents in place so that if you ever reached a situation like that, you would not have to go to the guardianship court. And I have an article here from the Lawyers Weekly a few weeks ago indicating that guardianship reform proving quite unpopular. I had indicated to people that it's now 3 to 4 times as complicated to get a guardianship. The lawyer in this article indicates it's 6 times as complicated. Figure out how lawyers get paid by the hour. So you're going to run into something that's horrendously difficult and expensive. So what you want to do is have these documents in place prior to any incapacity you may have. It's sort of like insurance. Leading into that, what we're doing, because I think this is so important, I no longer say it's recommended. I'm saying now it's mandatory to have these documents, both so that you control your own future and you save your family the going through a guardianship proceeding, which, believe me, is not a very pleasant thing to do. My office does them, but I'd much rather see you have the advanced care documents in place. What we've just put together is a advanced care planning and toolkit. This is about a 30-page document. It's a handbook which goes into quite a bit of detail as to what we're going to be talking about today and the different factors you should consider. This is in the process of going to the printer. This will also be available. You can contact my office either on the website or call me at 398-3037. The other thing we're doing, which we've been doing now for 4 or 5 years, is we'll have a set of forums in May where we will address a lot of these issues at the graded school in West Dennis. We will also be doing the same presentation in Provincetown in May. And I would just direct you to next month's prime time or again to my website.
So interjecting, there's no excuses. You have
None,
to do this stuff.
None. You have to do this stuff. And I'll tell you, in the last couple of weeks, I've seen situations where these documents haven't been done, and we're trying to get a guardianship rolling, and it's extremely difficult. There are some mechanical requirements that make it really, really difficult. I have a couple now. It's very unfortunate. They're an elderly couple where the wife she's in and out. And we made an attempt to go to the house the other day to do these documents. We couldn't do them. We're going to try again. And I'm doing a lot of this where it's so important. If the person has sufficient capacity, we will do them. The other thing we're doing, if someone has a health care proxy in place and a situation arises at the nursing home where it's going to be much easier to use that health care proxy, but there may be some questions as to its effectiveness, we can go to the probate court and in a much simpler procedure have the health care proxy verified. And that way the court will give its stamp of approval, and then once again we will avoid a guardianship. So I think, as Barbara indicated, no excuses. Everyone should have these.
And an important thing, just to interrupt for a minute, is the document that Arthur is talking about, the 31 pages, is so important, not only because it helps you piece by piece to plan, but the documents that we've had in the past are things like 5 wishes and help and documents like that many of you who watch the station have heard either myself or other people talking about. And the difficulty is with those is that they were designed or started in a state that is not Massachusetts, California being one of them. And the laws are very different there than they are here. For example, we have people who come in all the time with living wills, but Massachusetts, if I'm not incorrect, doesn't recognize properly living wills.
But living wills are not enforceable in Massachusetts, and that's not to say we don't use them, and that's part of what we're going to talk about this morning. But Barbara's absolutely right. Massachusetts has some very odd and different rules and regulations and law, and you have to be very, very careful when you use documents that you either acquire on the internet or from another state, because you may be doing something that is non-enforceable in Massachusetts or just doesn't exist in Massachusetts.
We had a family member, when my parents were both in Florida, they had a living will, and a family member had gone with them to a lawyer, and this was supposed to be a reputable lawyer, who told them that all they needed to do, I laugh now, they're both gone, but is they needed to do a videotape of themselves, basically saying what was in the living will. And Arthur's laughing also because it's just ludicrous. That doesn't really do anything. It might help the family members, but it doesn't do anything as far as a court or the law is concerned. So you really do need to know what is in your state, and that's what Arthur's going to be talking about today.
Just to go a little further on that, up until a few years ago, I was not doing living wills because of the fact they weren't enforceable. However, as you recall, we had the Terry Schiavo case in Florida, which basically revolved around a living will concept. And that's why we do them now, I do them now, and a lot of attorneys do them, with the caveat that they're not enforceable, and I'm going to go into that a little further. The reason I was kind of laughing when you talked about videotaping things, I was at a seminar a few weeks ago, and the issue of videotaping wills came up. And I know a lot of attorneys were enthused about that, but more often than not, it will show perhaps that your client doing this will is completely bonkers, which is the thing you don't want to do. So I always question when people want to videotape, but as far as I know, that would not work in Massachusetts.
No.
So what I'm going to do then, I'm going to just go over healthcare proxies and how they work in Massachusetts, and I will coordinate that with a discussion of living wills, advanced care directives, and the HIPAA authorization, which is a fairly new federal law, which is very important in this overall scheme of things.
The first question we get all the time, Arthur, is with a healthcare proxy, does it have to be notarized?
Healthcare proxies do not have to be notarized under the law. I think you're contemplating sometimes in a hospital scene where it may be a little frantic. When you walk in the door of the hospital for anything beyond having a splinter removed, they're going to throw one of these standard forms at you and get you to sign it. And one of the problems I have with that is you're doing that under duress, and it's a very, very fundamental document. There's nothing wrong with it, but it's the bare bones, and that does not have to be notarized. When I do them in my office, and we've had a chance to go over them, you may want to make changes. You may have religious scruples that would make that standard form something you wouldn't want to use. I then notarize them. There are different requirements for different documents where sometimes you don't need witnesses, sometimes you don't need notaries. I believe in the belt and suspender theory because another question that comes up, can these documents be used outside of Massachusetts? Yes, they can. So what I want to do by notarizing and witnessing everything, I assume I'm going to cover all out-of-state requirements because some states may require that things that don't have to be notarized here are notarized or don't have to have witnesses, so I do everything. But specifically, the healthcare proxy does not have to be notarized, but I think it's a good idea to notarize it. So, accidents can happen to anyone. Strokes can happen to anyone. We're not necessarily talking about people of advanced age with Alzheimer's in a nursing home. At any given time, you could become a person who's incapacitated and would not be able to communicate your wishes to the physician, which is the standard we use. There were some well-known cases back in the late 80s and early 90s which led to the rise of this uniform healthcare proxy statute, which Massachusetts adopted in 1990, so that you can, in following the statute, and that's what I'm going to do as we proceed this morning, you can indicate your wishes as to who you would want to speak for you in the event that you cannot speak for yourself. Now, again, I've already mentioned the standard format that you see when you go to the hospital. I'm sure the senior center has them also. The one I use in my office has been adapted, and I've added different things into it. And again, the healthcare proxy in Massachusetts is designed for the most part to address ordinary healthcare issues, the things that we see day in and day out. Now, over the years in Massachusetts, certain things have grown up both through case law and legislative law that have been deemed to be extraordinary incidents or extraordinary situations. And these sometimes cannot be addressed by a healthcare proxy, and you may have to go to the guardianship court, which is the probate court. What I've tried to do is adapt my particular healthcare proxy to address these situations. And I've recently amended the basic healthcare proxy I use to include the new things that have come into being because of the new statute. And again, I'm trying everything I can to make these documents sufficient so that if any of these particular extraordinary things occurred, you wouldn't have to go and get a guardianship. So very briefly, I just want to go over those things, and some of them you may be familiar with. Prior to the change in the guardianship law, when you applied for a guardianship, there was always three things they would ask you about whether you were seeking authority. They were all in the mental health field, and they're still all there, and there's one additional one. The first one is there are certain medications that are used, they're used quite frequently in nursing homes, and if you read about them, they're sometimes in the paper. Barbara and I attended a conference about 3 weeks ago, very well attended, where we had the head psychiatrist from McCall's and the geriatric division down talking about these drugs. And they're called neuroleptics. They're primarily antipsychotics, Risperdal, Seroquel, drugs of that nature. Under Massachusetts law, if someone who's deemed incapable of assenting to the use of that medicine is going to be prescribed that medicine, you have to get a guardianship, and it's called a Rogers guardianship. Now, I've incorporated these into my healthcare proxy, and we do know that in a nursing home setting, based on a letter from the Division of Medical Assistance a few years ago, that will work. So if your loved one is prescribed, say, Seroquel by the treating doctor, you talk to the doctor about, well, why do you want this, doctor? What are the possible side effects? What will happen if we don't use it? What will happen if we do use it? You're authorizing your healthcare proxy to make that decision for you. And that will work in a nursing home context. And this is why quite frequently we are verifying healthcare proxies, because it's usually in the context of using one of these medicines. What we're talking about this morning, the concept of are these medicines properly used, et cetera, is way beyond our scope. That's what that meeting was a few weeks ago. The other thing you always had to ask permission of the court was to place someone in a locked facility. This is not the Alzheimer's wing at your local nursing home. This would be a state hospital or maybe a geriatric psychiatric wing. That still exists under the new law, but it's no longer in the probate court. It's over in the district court. So when a few years ago you could go into the probate court and under one guardianship action you could accomplish a healthcare proxy, you could take care of those situations. If you had to admit or commit someone, you could take care of that. And if there were financial issues, you could do that all at once. Now you may have 3 separate court cases because of the way the new guardianship law works. And I'm going to go into detail on that later on. The new one is you now need permission of the probate court to admit someone to a nursing home who otherwise is not competent to admit themselves. And this has caused a huge uproar amongst the nursing homes. And this includes just going for 1 or 2 days rehab after an operation. You've got to go through this whole huge process at the probate court. Now, there is some talk that that's going to be amended, and that may be changed in the present law. So
can I just ask a quick
Sure.
question? So if you were at the hospital, you're at Cape Cod Hospital, you've fallen and broken a hip and you live by yourself and you are not completely competent or you have early Alzheimer's symptoms, does the hospital then have to go to court on your behalf, or do they have to get somebody like yourself? Or?
Well, this is still working out, and I have a client that was in the other day who's actually a nurse, and she'd never heard of this and didn't know it was happening. And basically, it's up to the receiving facility, because the receiving facility is the nursing home. They have certain license requirements. That's why when they're going to use one of those drugs I just talked about, it's very important that they either have in their file the healthcare proxy with the permission to use the medicine, or one of these guardianships. Under the new law says that unless the person checks themselves in, you need permission of the probate court. So again, this may be one of these situations where I'm telling you what the law is, but I don't know what's going on out there. But I'll tell you, I get calls from a lot of nursing homes that are very upset, and I had someone
They're
we
probably
know.
suddenly like, uh-oh,
Yep,
after they've already received
someone
them.
we know that had to go in for at most a week's rehab, and I had to go in to the probate court and get special permission, and that applies even if it's for a day. The change they want to make to the law is to exclude anything under 90 days. So that would cover the hip replacement, the open heart surgery, and that may be done. So the receiving facility is taking a chance that that might be the week that the inspector's coming down to check the books, and they'll say, wait a minute, you don't have the proper paperwork.
And taking a chance that they may not have one of those Rogers drugs, and suddenly the psychiatrist comes in and decides to give them one.
Right. This gets really complicated. So again, I'm back to, I know that the Rogers thing works with the healthcare proxy. A few years ago, McLean's admitted someone to their facility using a healthcare proxy. Admitting someone to the nursing home, it's brand new. It hasn't come up yet. I've put it in there. And the last thing was just this overall, any extraordinary care. Years ago, that primarily referred to electroconvulsive therapy, otherwise known as shock treatment, which you don't see much of anymore. But what I have included now is something that comes up a lot with me, where I'm guardian of other people, is the authority to place a do not resuscitate order. That is considered extraordinary because, in effect, you may be ending someone's life. But then you get into do not intubate, do not do this, do not do that, a lesser level. And then it just becomes a gray area as to what extraordinary is. The example I use in my office is if you ask a neurosurgeon who maybe does 8 brain operations a week, is that ordinary or extraordinary? Well, he's probably going to say it's ordinary. I do it every day. You or I are going to say, no, that's extraordinary. And then get back to the example I mentioned earlier, having a splinter out. That's pretty ordinary. But in between, there's a whole host of things. An amputation of a leg and a diabetes, is that extraordinary? I don't know. It's something that has to be dealt with. So we try and deal with that in the changes I've made to the healthcare proxy. Now, when you do a healthcare proxy, you're going to name one person who's going to act in your behalf. And the requirements are just that that person be over the age of 18 and be competent. It's also a given that you should be competent to execute a healthcare proxy. In Massachusetts, all people are assumed to be competent until shown otherwise. The level of competency doesn't have to be extraordinarily high. You just have to know the import of what you're doing. You can also name a backup. And I'm a firm believer in this, that you name the first person you want and then you name a backup. I don't let documents out of my office without backups. Now, one thing about a healthcare proxy, under the law, you can't name a second, third, fourth, and fifth backup. So if you have a number of children, you have to realize that the healthcare proxy is pretty much governed by this statute. And I've done it before where people have asked me, but you want to name one person and you want to name a backup. Again, the guide that we have is very good on this, and it's also very good on something that occurs every once in a while. I have people that come into my office that don't really know a lot of people. They may be single and don't know people. If you're going to name someone, why don't you check with them and let them know you're going to name them. I've had situations where people get a call at 1 in.the morning from a hospital. They're on someone's healthcare proxy and they had no idea.
That's been me before.
Okay, so it's a good thing, and I'm going to tell you why that's a good thing.
And to interject, not you do need to know the person really well, and they need to know you really well, because I've had that happen where I really, because of my job title, can't be somebody's healthcare proxy or shouldn't be. Not that I can't be, I shouldn't be. And I have had that happen where I've gotten named, the hospital calls me, I have to come up. I know the person, friendship-wise, if you want to call it that, but I have no idea. We've never had a discussion about their medical issues or what they would want or what they wouldn't want, and suddenly they've had a stroke and they're in Cape Cod Hospital, and the doctor's saying to me, so do you want to do, fill in the blank? And they have no family, and they put me down. So not a good choice.
No.
You need to have someone who knows you well, someone you know well, and someone you've had a conversation about this with.
And I'm going to tell you why this is so important. Let me just present a little scenario. As Barbara said, you get the call at midnight. The examples I use, you're in the motor vehicle accident. That could happen to anyone at any time of any age. You arrive at the emergency room, you're unconscious. The standard to use a healthcare proxy is when the treating physician cannot communicate with you. Okay, this could be as a result of the fact you're unconscious, you're in the emergency room. Or you could be of advanced stage with Alzheimer's where there's no real communication. So the doctor is then going to make inquiry, is there a healthcare proxy? Because the doctor is the one that activates it. He's supposed to do it in writing. Think of it as a faucet, and this is not a real faucet. He turns it on and turns it off. And we're going to talk a little later, well, how does he know you even have one? And we're going to talk about the mechanics of that. But here's why it's so important to talk to the person you've named. I had a situation a few months ago where I was named, and the court will name me when situations arise where people who have no one or their family doesn't want to be involved and they don't have these advanced care directives. I will get the phone call, will I do something? And in this instance I did. I arrived at the hospital, come to find out that what I thought was going to be a very simple case, there was a neurosurgeon who wanted to do brain surgery on this person. And 1/2 hour after I met them, he wanted to know if I would assent to the brain surgery. I said, well, let's think about this for a little while. And he kept on harping away that this is in her best interest to have this surgery. I had to explain to him, and this is very important, this is not a best interest state. Massachusetts is what's called a substituted judgment state. That means you are obliged to do or express to the doctor that which the principal or the person that made the proxy out would want done in this particular situation. So as Barbara said, if you've never had a conversation with them, and again, the handbook will lay out 20 different scenarios. If this happened to me, this is what I want. Not necessarily what's in my best interest, and you may not agree with them. Gee, I don't think that's a good thing to do. Well, that's what I want. Well, this woman had a long documented history of, I want nothing to do with doctors. I don't want to take medicine. I don't want surgeries. I don't care if I'll die if I don't have this surgery. I talked to the family members that I could, and I went back to the doctor and said, this may be in her best interest from your point of view, but I have to apply in Massachusetts the substituted judgment. And based on what I've been able to tell, and I did speak with this woman for a short amount of time, she doesn't want this. So I have to reflect what she wants, which is she doesn't want the surgery. Well, the surgeon wasn't too happy. And guess what? 2 weeks later, I got a phone call. The x-rays had been read incorrectly. She didn't have a brain tumor.
Oh, my God.
Now, that has nothing to do with the law of the thing.
Wow.
But it's extremely important that you know what the person who made this proxy out wants. Now, you may have a situation that arises where something really off the wall occurs that you've never discussed. Then you can apply a best interest standard. Then you could say, well, based on what she's told me and everything, I would guess this is what she'd want because it appears to be in her best interest. But other than that, you have to reflect what the person would want, and that's why you have to talk to them. That's why it's important that you also talk to your backup person that you appoint. That's where I think the living will and the advanced health care directives can play a very important part. So that is so important, this concept of the substituted judgment. It's not what you think, it's not what the doctor thinks, it's what the person would want.
It's also not your beliefs. We've had that come up too, where you've had a person who is very religious, and I'm just going to use myself as an example. I was raised and am a strong Catholic. I have a very strong faith. And if I had somebody who was a Christian Scientist that I was a healthcare proxy for, which would never happen, but if it did happen, I cannot project my religious beliefs or my own faith beliefs onto that person. You have to back up what their belief system is, what their wants and their wills are. So you really do need to know the person well, and you need to have the backup know the person well as well. We had a situation where a woman who had cancer, she's still alive. She's been told for 12 years that she's actively dying, and she's outlived all of her healthcare proxies and people that she has named in her will. She's had to redo them several times. So you do need to know the person well, and things can happen to your healthcare proxy or your backup. So you do need to have some others in reserve.
That's right. And this is, as I mentioned earlier, sometimes you want to custom tailor your healthcare proxy to reflect your religion, be it Christian Scientist, Catholic, Jewish beliefs. We recently had a Christian Scientist case, and we thought it may have had to go to court because there was a strong indication from the treating doctor that using one of those medicines on that special list would be in order. Well, this is a Christian Scientist who does not use medicine. So I happened to be talking to the judge about this case, and when we call these a Rogers case, that's just another fancy word for a substituted judgment case. He said if that case came in front of me, I wouldn't have to think about it for more than 2 seconds. She's a Christian Scientist. All her life she said, I'm not going to use medicine. Case dismissed. We're not going to use it. So that again is very important that you know these things. It may be something that you don't want to do, but you have to reflect the wishes. And if there are religious beliefs involved, you have to follow those. And as I get a little further on, that has caused problems over the years in certain contexts. So again, remember, in the example I gave you, you're in the emergency room, you're there because of an accident, and 2 hours later you come to, and you seem to have your wits about you. The doctor then turns off the healthcare proxy and will start communicating with you again. Now, if it's the situation where it's a quite elderly person with Alzheimer's, that's probably not going to happen. And very frequently, we will call nursing homes and say, has the doctor activated the healthcare proxy? Hoping that there's one in place. If there isn't one in place, we know where we're going next, and that's over to the probate court. So this is very, very, very important. Now, you have a healthcare proxy, and this reflects your wishes. You can change your mind. As Barbara said, you may have people that have passed away. There are a number of reasons why you change your mind. But to get back to verifying the healthcare proxies, sometimes in a nursing home context, certain things that can happen which may be considered a revocation of the healthcare proxy, and the most common one is a patient spitting the medicine out. But this person may have already been diagnosed as incompetent by a treating physician because of advanced Alzheimer's. So the question comes up, how can someone who's not competent revoke a legal situation? And this, again, may get us over to the court. But at least if there's a healthcare proxy in place, we're going to avoid having to get a full-blown guardianship, if at all possible. Now, I had mentioned, let me mention one other thing. There are certain things that the hospitals can do even without a guardianship, even without a healthcare proxy. And one of these is just to give you pain medicine, to alleviate pain. If there's some medicine you're already on, they can go ahead and do that under certain emergency powers. Again, of course, if you have a Christian Science situation, that could be a problem. Now, some years back, there was a case that came up. It's called the Brophy case, where a fireman in the Boston area suffered irreversible brain damage, and was placed in a local hospital, and he was in a vegetative state for quite a while. The hospital he was in was a Catholic hospital. And when it came to a question of removing life support, we had some real problems. And that went to court. And basically what the court held in that particular case was that if there are religious considerations like this, they're not going to force the hospital to go ahead and honor whatever the person wanted. The solution then would be to find a different facility. Also in the law, there's a provision that if you don't have a healthcare proxy, but you have a power of attorney that mentions healthcare proxy terms and powers, that would serve in a pinch. But it's still better to have a standalone healthcare proxy. And there are different names for this. Some states, they call these power of attorney for healthcare. We don't call them that. They're called healthcare proxies in Massachusetts. And remember, substituted judgment. That's extremely important in Massachusetts. Now, the sheer mechanics of doing this. For instance, when someone comes to my office and we're going to do a healthcare proxy, we'll talk about the religious beliefs. We'll talk about anything else that may concern them. We'll talk about who would be a good choice. And once again, we're going to urge everyone to use the toolkit. And quite frequently, with a husband-wife, they're going to pick each other. Unless we have situations where one or the other of them already appears to be developing a dementia, then we're going to want to step back a little bit and see if this is a wise choice. Maybe a child. Then you may name one of your children as a backup. If you're a single person, again, you have to take into consideration all these factors we've talked about. So what we then do is we prepare the advanced care directives in triplicates, triplicate originals. And the reason for that is, number one, sometimes these things get lost, and a lot of times, or most times, people will leave an original at my office. The question comes up, well, what do I do with the others? Again, this is the line down the middle of the table. I don't know your family dynamics. Do you want to give an original to the child you've named as a backup? You may not have to give one to your spouse if you're at home. That's something for you to determine. You should absolutely give a copy to your treating physician. And if you have more than one doctor you see quite a bit, you want to give maybe give a couple of copies out to each of the doctors. You can also put one on file over at the hospital. Anyone on the Cape who's ever been to the hospital for any reason, you have a permanent chart over there. That way you can avoid every time you walk in the door, they throw one of these forms at you. I've had people that have filled those things out 10, 20 times. Now let's get back to the question. You've arrived at the emergency room. You're unconscious. How do they know you have a healthcare proxy? You can't tell them. So what we do at my office is, number one, I have my business card, which says healthcare proxy on the back. So we put that information on the back. We laminate the card. We give it to you and say, put it in your wallet right next to your insurance cards, health insurance cards, because they're going to look there no matter what else they do. So they will probably find it. The newest thing we're doing is putting all the information, all of the advanced care directives on these little computer flash drives.
This is very cool.
Yes, we like this. So when you get to the we have the pink and white for the women and the blue for the men. When you get there, and we are trying to put on the back of the card that you do have a thumb drive, they will take the tip of this off and stick it in the front of the computer. And on this little drive will be your healthcare proxy, the whole thing, with your backup people, with their cell phone numbers, and if you have one of these that's custom built, so to speak, all these little exceptions that are included, that might be a big help. It'll also have your living will and your advanced care directives and your HIPAA. So we like these. That's fairly new that we're doing, and we think that. I know I have some people that they carry the papers with them all the time in case something happens to them. That can be a problem.
Another place they
Yeah.
could put your card that has the healthcare piece is in their File of Life pouch.
That's true.
Because rescue takes them when they
Right.
go to the hospital. At least they'd know right away.
Right. Of course, when I give the example of you're in the car accident, that's not going to be an option.
It
Because,
should be. They should have it in their glove compartment as
okay,
well.
that's a good point.
We're trying to make them do
And
both.
someone said to me, well, with your example, if they put these on the keychain, the keys are probably still being the ignition.
That's true.
I hadn't thought of that one. But anyway, it's the thought that counts. Okay. What's a living will? A living will is a document wherein you indicate your thoughts about end-of-life issues. That sort of segues into advanced care directives, where you say, you know, this is what I think about life, and these are my thoughts. I don't want to be in this particular condition, and if this ever happens to me, please do the following. Since these aren't enforceable in Massachusetts, the one I'm presently using is very short and succinct. It just says, if I reach this situation, please don't take heroic measures. In states where these are enforceable, and I'm back to California again, I happen to be licensed in California, the living will and advanced care directive out there is much longer than the healthcare proxy because it's enforceable. It's 12 pages long.
Wow.
And they go through every conceivable situation, including donating your skin to the local plastic surgeon for those people that have sun damage from being on the beach too long. I don't think that's going to come up around here. Now, in Massachusetts, these are not enforceable. Then why are we doing them? Because they do give guidance to the person that you've named, and they can be helpful in a situation if you have to go to court. If you have a a living will here that says, if I find myself in the following situation, please do not take heroic measures. Please do not have me hooked up to machines. Now, in Florida, it's my understanding you could run to the court and the judge would stamp that. You could run back to the hospital and perhaps they'd unplug the machine. Here, if you went to the probate court, the judge would look at it and say, well, that's very nice and that's indicative of the wish of the person who's in the hospital, but there's nothing I can do about it. So again, where it comes in handy especially is when this duty is going to fall to your backup healthcare proxy, who may be an adult child. It's not the person you've named initially. And they may have feelings of guilt and, boy, I don't want to do this. But if they see it in writing, it's going to ease their mind quite a bit. Now, why we don't have enforceable living wills in Massachusetts, I don't know. There's all sorts of guesses. But I'll tell you why doctors in particular don't particularly like these things. First of all, they don't like sitting down and reading them. And in California, it's 12 pages long. I can't imagine a doctor's going to do it. And I have a lot of doctor friends and clients. I don't want to get them annoyed at me, but doctor knows best. Studies have shown that 70% of the time, they're not going to agree with what you're saying, and even though it's up to you. The examples I like to use are, let's say you do a living will when you're about 40, and in it you have, if I can never dance again, pull the plug, I don't care. As you reach 60 and 70 and 80, you may change your mind, and if you had an enforceable health care directive or living will, you probably want to change it. If I ever get the ABC disease, I don't want to, just let me go. Well, they may have come up with one pill, you take it, and the ABC disease has gone away. So those are some of the reasons doctors don't like it. But again, we're doing them now. I don't believe in mixing the language of the advanced directive in with the healthcare proxy. They're two separate documents. Now let me get to HIPAA. HIPAA was a federal law that went into effect maybe 7 or 8 years ago. HIPAA, Health Insurance Portability and Authority Act. It was originally designed so that if you had health insurance and you went from job to job, you could take it with you, hence the portability. But they also added in this authority portion, which makes any of your medical information super top secret if anyone reveals that they can go to prison. And when you have a doctor or a nurse seeing that, they take it very, very seriously. I have a lawyer friend, took her daughter to the oral surgeon, you know, the 2 hours, then you pick them up afterwards. She went shopping, called back and said, is my daughter ready to be picked up? I'm sorry, ma'am, I can't tell you that. It's a violation of HIPAA, and you don't have a HIPAA authority here for your daughter. That's extreme. So what we do is you generally are going to name the person who's your health care agent and the backup, if you want, to have full access to your medical information. We also include that in the healthcare proxy. We include it in the power of attorney because it's very difficult to discuss health matters with a doctor if he can't talk to you because he doesn't have the authority to reveal the information. So that's the package that we do for advanced directives for anything relating to your health. This is so important, mandatory, because if you don't have these in place and you wind up in the hospital and you are in a coma or you are in the nursing home with a dementia, then it's off to the probate court, and it's something you really don't want to do because of its complexity. So in the alternative, do these documents. And in our next session, we're going to talk about the last portion of your basic documents, which is those which will handle financial considerations. So any follow-ups, Barbara?
Not that I can think of. I will tell you just very quickly, with my own family, we had my mother in that kind of a situation. She had had the tube down her throat, and her sister, that she hadn't spoken to in many, many years, came in demanding to know all of her medical information from the nurses and doctors. Thankfully, they didn't give it to her, and she was livid. This is my sister. I have a right to know. Well, when we finally got to the hospital, we said, actually, you don't, because that's not what our mother wanted. So they enforced it properly up at...
That's correct. And the HIPAA, under HIPAA law, they cannot release that information without that authority. Now, that example you brought up, you could sometimes arrive at the hospital, and let's say you've had a really bad accident, and the only way they're going to keep you going is to put you on all these machines and breathing machines and intubation and everything. And they can do that because they can do things to keep you alive. But let's say after that's done, we discover your living will and your advanced care directive, and you're indicating, if this ever happened to me, I don't want to go on. Well, now, based just on that alone, will they start pulling the plugs? It's a lot easier to get you hooked up than to get you unhooked. You may then be bumping into the ethics committee at the hospital. The hospital may start worrying about their own liability. You're into my favorite area, the gray area, okay? You may wind up in court even though you don't want to, and then they'll have these people called guardian ad litems appointed, and it can get to be really something. So your best defense is to have all of the paperwork that you possibly can in place and be armed with a little knowledge of these things, as Barbara points out, so you don't get blindsided.
And it's a lot less costly in the long run.
In the long run, compared to what a guardianship would cost you, we're talking 10 times as expensive if you wind up. In the guardianships, and sometime down the line, we're going to do a segment on guardianships. They never go away. They're going to be there as long as this person is there. There's all sorts of reports you have to make to the court. The paperwork has increased tremendously. This grew out of a situation that occurred in Suffolk County a few years ago. We're very lucky down here, both in our hospitals and in our long-term care facilities and in our courts. We never had those situations, but the law is statewide, and we have to live with it. So please get these documents done however you can. Be careful if you're going to go to the internet. You can get yourself in trouble. But other than that, do something.
Well, thank you very much for coming. We will have a set of 4, as I said, and possibly more after that. And this is the very first in that series. Thanks for tuning in.